Okay, let's unpack this. Imagine you're watching security footage of a crime. There are masked figures, chaos, maybe a hooded face captured for just a second. You'd think that photo, that visual record, would be rock solid evidence, right? The clearest path to identification.
You'd think so. But what's truly fascinating in the sources you brought us is how exactly that kind of visual evidence specifically,
Hmm.
quite grainy security camera photos, became the absolute core of this legal battle. A battle that reshaped courtroom practice all the way up to Australia's High Court.
Yeah.
This isn't just a story about a crime. It's a deep dive into how the justice system really grappled with, well, technology and pictures and redefined what proof from an image actually looks like.
Exactly. For this deep dive, we're sifting through court judgments, background notes, basically everything we could find on a case, often called Shadow in the Frame or sometimes the Hooded Bandit case.
Right, Smith v. the Queen.
That's the one. And it takes us from a robbery in suburban Sydney right into the highest legal chamber in the country. It's quite a journey.
Our mission, looking at these sources, is to follow that specific journey, step by step. We need to understand the people involved, the key players, track the legal arguments as they sort of wound their way through the courts, and pinpoint exactly how those few blurry pixels in a photograph sparked this landmark decision, a decision that fundamentally changed the rules for identification evidence in Australian law. It's huge.
It really is, and it's a narrative filled with tension. On one side, you have Mundarra Doolan Smith, the young man accused, navigating a system where simply being known to police, especially coming from places like Redfern, could suddenly become key evidence against you.
Yeah, that's a definite undercurrent. Then there are the police officers, Senior Constables Crampton and Peterson. Their prior familiarity, their previous interactions with Mr. Smith became the critical plank of the prosecution's case. Their claim that they recognized him in those security photos.
Right. And pitted against them is the defense team. The sources highlight Patrick Byrne, SC, who relentlessly challenged whether that kind of recognition should ever be allowed as evidence in the first place.
In representing the state, arguing to uphold a conviction, you had the NSW Solicitor General Michael Sexton, SC. You can see the weight behind this. It wasn't just about this one case. It felt like it was setting a precedent for how, I guess, potentially millions of security camera images could be used in courtrooms going forward.
Absolutely. So we're going to follow the procedure, okay? From the initial charge through the trial, the appeals, all the way to that pivotal high court showdown. So let's start at the beginning. What do your sources tell us about the crime itself? How did this all kick off?
Well, it all began on the morning of June 26, 1997. According to the sources, a bank in Caringbah, which is a suburb of Sydney, was robbed.
Okay.
4 young men acting together took money from 2 bank officers during the incident. Pretty standard armed robbery scenario on the face of it.
And critically, the bank's security cameras were rolling. They captured images of the robbery as it happened.
Yep.
Now, the fact that the robbery occurred, that wasn't really the issue when Mr. Smith later went to trial, was it? The central burning question was whether Mundarra Smith was one of those 4 individuals caught on camera.
Absolutely. That was the whole case. And the prosecution's entire strategy, their whole case against Mr. Smith, rested on the ability to identify him as one of the people in those photographs. Specifically, the person described as acting as a lookout, sort of near the back of the ATM area.
So how did they attempt that identification? It wasn't like a traditional eyewitness pointing someone out in a lineup or anything like that.
No, not at all. This is where the case takes its unique turn and where the legal arguments really start. The prosecution called those 2 police officers we mentioned, Senior Constables Crampton and Peterson.
Right.
And they testified that, based on their prior dealings with Mr. Smith encounters they'd had with him before the robbery, they recognized the person in the bank security photos as him.
Hold on. So they weren't identifying someone they saw commit the crime. They were identifying someone in a photo because they knew them from before.
Precisely. They looked at the pictures later and said, yeah, based on knowing him, that's Mundarra Smith. And they maintained this recognition under oath in the witness box, despite objections from the defense.
Wow. And how crucial was this?
Absolutely critical. Your sources highlight this clearly. The prosecutor at the trial openly admitted that this police testimony was, and I think the quote is, almost the only evidence connecting Mr. Smith to the robbery, other than, the photographs themselves, which the jury could obviously look at.
Okay, so the police officer's existing familiarity with Mr. Smith, their encounters with him in the past, became the absolute linchpin. The whole thing hung on that recognition.
It really did. And this is where the legal fight began in earnest. So Mundarra Smith was charged with robbery and company, and he pleaded not guilty in the District Court of New South Wales.
And right from the start, the defense led by Patrick Byrne SC and his team, MD Austin and TS Corish, were with him at trial. I believe they challenged the admissibility of that police recognition evidence. What was their main argument against letting the jury hear it?
Their primary argument, according to the sources, was that this police testimony was inadmissible opinion evidence.
Opinion, not fact.
Exactly. They argued that the officers weren't stating a simple fact like, I saw him there. They were giving an opinion, in my opinion, based on comparing this photo with my memory, that's him. And generally, opinion evidence isn't allowed unless it fits a specific exception in the rules of evidence.
Right, the classic legal distinction. Opinion evidence is usually excluded.
So how did the trial judge, Latham DCJ, rule on this? This was obviously a crucial decision right at the start, decided after a voir dire, a sort of mini hearing without the jury.
Yeah, it was huge. The prosecutor, R.D. Ellis, who appeared at trial, up front acknowledged the challenge, stating there was very little other evidence besides the photos themselves. The police officers detailed their prior contact during this voir dire. Okay, what did they say?
Senior Constable Crampton mentioned 3 brief conversations, and seeing Mr. Smith in passing about half a dozen times over a couple of years. Fairly minimal contact, really.
Right.
Senior Constable Peterson, though, had more significant contact. He testified he'd spoken to Mr. Smith 5 or 6 times while working in Redfern, and crucially had arrested him a couple of times, spending maybe 2 to 3 hours with him on each of those occasions.
Okay, so much more interaction there, but still based on prior dealings, not the crime itself.
Yeah.
And the defense also argued this was prejudicial, right? Letting the police say they knew him from before kind of hints he's got a record.
Precisely. Byrne SC argued this point forcefully, asking the judge to exclude it under sections 135 or 137 of the Evidence Act, which deal with unfair prejudice outweighing the value of the evidence.
But the judge allowed it.
She did. Judge Latham rejected the prejudice argument, and on the opinion issue, she seemed to think it might not even be opinion evidence, perhaps just a statement of fact based on recognition. But even if it was opinion, she thought it might be admissible under the lay opinion exception in Section 78 of the Evidence Act, 1995, NSW. So, bottom line, the evidence was in.
Okay, so the police identification evidence stayed in, the trial proceeded, the jury saw the bank security photographs, which were formally entered into evidence through, I think, a photographic laboratory technician.
That's right, just establishing the photos were authentic copies. And then the police officers testified again, this time in front of the jury, repeating their recognition evidence.
And the cross-examination by the defense.
It focused understandably on things like the poor quality of the photographs, how clear or unclear they were, and the nature of the officer's prior contact with Mr. Smith, but they had to tread carefully, not to bring out the really prejudicial stuff like the actual arrests.
Right, a fine line to walk. And Mr. Smith himself didn't give evidence.
No, he exercised his right to remain silent. His mother did testify, but interestingly, your sources note she wasn't asked directly in court if she recognized her son in the photos, although apparently she had previously told police she didn't believe it was him.
That's interesting. Now, this is where you really get a sense of the jury's struggle, isn't it? The photos must have been pretty unclear.
Absolutely. Your sources reveal something quite extraordinary. The jury sent a note to the judge asking for a magnifying glass.
A magnifying glass. Seriously, that really underscores how difficult it must have been for them to make out the faces and how much they were trying to figure it out for themselves. Did the judge give them one?
No, she didn't. Judge Latham told them that their task wasn't to become super sleuths with magnifying glasses.
Right.
Instead, she directed them that the core issue was whether the police officer's identification, based on their prior knowledge and what they saw in the photos without any special aids, was correct. The focus had to be on the reliability of the police evidence.
That's such a critical direction. It really pushed the jury away from making their own independent comparison, which they clearly wanted to do, and steered them back towards just assessing the credibility and correctness of the police officer's claims.
Exactly. And they also asked another question, didn't they? About whether they should only rely on the specific photos the police used for identification, or if they could look at all the photos provided.
Yeah, what was the judge's answer to that?
She clarified they could look at all the photos admitted into evidence. But she reiterated that the prosecution case depended entirely, or almost entirely, on the police identification from those photos. So the ultimate question remained, were they satisfied that the police identification was correct?
So despite the defense's persistent challenges to the evidence, led by Byrne SC, and the jury's obvious difficulties shown by their questions, Mr. Smith was convicted by the jury.
That was the outcome at trial, yes. But it wasn't the end of the road.
No, definitely not. So, naturally, represented again by his legal team, including Patrick Byrne SC, Mr. Smith appealed his conviction. Where did he go first?
To the Court of Criminal Appeal of New South Wales. The grounds of appeal were essentially the same ones argued at trial. Primarily, that the police recognition evidence was inadmissible opinion evidence and should have been excluded under Section 76 of the Evidence Act. And secondarily, that even with that evidence, the conviction was unsafe or unreasonable given the poor quality of the photos. So they doubled down. They stuck to their guns saying this type of police identification just shouldn't have been allowed at all.
Exactly. It was the core issue. However, the Court of Criminal Appeal, the judgment was delivered by Justice Scheller, with Justices Mason and Sully agreeing they dismissed the appeal.
They dismissed it. On what grounds?
They essentially sided with the trial judge's reasoning, or at least her conclusion. They concluded that the police officer's evidence wasn't opinion evidence at all. They saw it as direct evidence of fact, the fact being that the person in the photo was the accused based on the officer's recognition.
So they're saying that's him is a statement of fact, not opinion. That was their view. And if it's evidence of fact, then Section 76, the rule excluding opinion evidence, simply doesn't apply. So according to the Court of Criminal Appeal, the evidence was properly admitted.
Wow. So the defense argument fails again? This case is clearly not going to stop here, is it? This feels destined for the High Court.
Absolutely. And that's exactly where it went. Mr. Smith sought and was granted special leave to appeal to the High Court of Australia. Your sources note, as a small procedural quirk, that two separate but identical notices of appeal were filed, one for each notice of intention to appeal, which the court found unnecessary, but they dealt with both appeals together.
Okay. And looking at the legal teams listed for the High Court hearing, it really underscores the significance of this case, doesn't it?
Definitely. For Mr. Smith, the appellant, you again have Patrick Byrne, SC, leading the charge, this time with MD Austin and TS Corish, and importantly, instructed by the Sydney Regional Aboriginal Corporation Legal Service.
Right. And for the respondent, the Queen, representing the state of NSW.
It was the Solicitor General for New South Wales himself, MG Sexton SC, appearing with R.D. Ellis and B.K. Baker, instructed by the Director of Public Prosecutions, NSW, top lawyers on both sides.
Clearly high stakes. So the High Court, this is where the deep legal dive happens. What was their approach? Did they just rehash the fact versus opinion debate?
Well, this is where it gets really interesting. The joint reasons of the majority judges, that's Chief Justice Gleeson, and Justices Gaudron, Gummow, and Hayne, they took a step back. They didn't immediately jump into the opinion question that had dominated the lower court. They asked a more fundamental question first.
Which was?
Was the police evidence even relevant?
Relevance. You mean, did it actually help the jury decide the key fact?
Exactly that. Under the Evidence Act 1995, which applied here, specifically Section 55, evidence is only relevant if it could rationally affect, directly or indirectly, the assessment by the tribunal of fact, of the probability of the existence of a fact in issue. If it's irrelevant, it's simply inadmissible. Full stop. The majority saw relevance as the absolute gateway question.
Okay, and the fact in issue here was simply, is Mundarra Smith the person depicted in those bank security photographs?
Precisely. That was the single disputed fact. So the question became, could the police officers standing up and saying, yep, that's him, rationally help the jury decide if that was true?
And the majority's answer?
A clear no.
Why not? What was their reasoning? It seems counterintuitive, doesn't it? Someone who knows the guy says it's him in the photo.
It does seem counterintuitive at first glance, but their core point was this. The police witnesses had no special advantage, no superior basis for comparing the person in the photo with Mr. Smith, who was sitting there in the courtroom, than the jurors themselves had.
Because the jurors could look at Mr. Smith, look at the photos, and make their own comparison.
Exactly. The police officers relied on two things: their prior knowledge of Mr. Smith's appearance and what they saw in the photographs. By the time of the trial, the jurors had had ample opportunity to observe Mr. Smith in court. Probably, the judges noted, more sustained observation than the police officers had had in their prior brief encounters.
Okay, I think I'm getting it. The police weren't bringing any extra information or specialized skill to the table that the jury didn't already have access to. They were essentially just offering their conclusion based on the same raw data the jury possessed: Mr. Smith's appearance and the photos.
That's precisely the reasoning. The majority argued that allowing the police to state their recognition wasn't adding relevant evidence. It was effectively asking the jury to defer to the police officer's judgment, to substitute the witness's conclusion for their own assessment. And that, they said, isn't the function of evidence. It couldn't rationally affect the jury's assessment of probability.
So because it couldn't rationally assist the jury beyond what the jury could do themselves, it failed the relevance test under Section 55, and therefore it was inadmissible.
Correct. And because it was irrelevant, they didn't even need to get into the whole tangled question of whether it was fact or opinion under Section 76. The relevance hurdle knocked it out first.
That's a profound shift in focus. The lower courts were so caught up in the fact versus opinion distinction, and the high court majority basically said, hold on, let's rewind. Is this evidence even useful in a way the law recognizes?
Exactly. A fundamentally different starting point. But there was a separate judgment from Justice Kirby.
Ah, yes. Justice Kirby often had a different perspective. Did he agree with the outcome?
Yes, he agreed with the final outcome, that the evidence should have been excluded and a new trial ordered, but he got there via a completely different route. He disagreed with the majority on the relevance point.
Oh, why did he think the police evidence was relevant?
Justice Kirby took a more, perhaps, pragmatic view of the situation. He pointed out that these security photos were often unclear, faces sometimes obscured by hoods or poor lighting. He argued that police officers who had seen Mr. Smith in various real-world contexts, moving, talking, different angles, different expressions, might actually be better placed to recognize him in a difficult, static, perhaps partial photograph than a jury who only saw him sitting relatively still in the dock.
Okay, so he felt the police did potentially have an advantage, a different perspective based on their prior dynamic observations, which could rationally assist the jury.
Yes, that was his view. He felt that familiarity gained from dynamic, real-world observation could be a relevant factor when it came to identifying someone in a challenging photo, especially, he noted, when the accused doesn't give evidence to offer their own perspective or allow for more comparison. He thought it passed the fairly undemanding test of relevance in Tilty 5A.
Right. So if Justice Kirby found the evidence relevant, he then had to tackle the opinion rule, didn't he? The issue the lower courts focused on.
He did. And unlike the Court of Criminal Appeal, Justice Kirby concluded that the police testimony was indeed opinion evidence, not evidence of fact.
Okay. And his reasoning for classifying it as opinion.
He acknowledged the line between fact and opinion can be blurry. Even recognizing someone you know well involves some level of inference or judgment. But he emphasized the well-known dangers of identification evidence, especially from less than perfect photos like these. He also considered the context police witnesses potentially having a certain perspective or motivation. Given all that, he felt classifying this type of recognition testimony as opinion was the safer, more appropriate, and legally sound approach under the structure of the Evidence Act. He pointed to similar conclusions in other jurisdictions, too.
So for Kirby, it was opinion. Did it then fit under an exception like that lay opinion rule in Section 78 that the trial judge had tentatively relied on?
No, Justice Kirby said it didn't fit S78 either. He analyzed the wording carefully. Section 78 allows lay opinion if it's based on what a witness saw, heard, or otherwise perceived about a matter or event, and the opinion is necessary to understand that perception. The crucial words for Kirby J were matter or event. He reasoned that the police officers weren't witnessing the relevant event, the robbery itself. Their opinion wasn't based on perceiving the robbery, it was based on perceiving the photographs later on. Therefore, Section 78, which he saw as primarily intended for eyewitnesses giving their impressions of something they directly perceived happening, didn't apply to this situation of post-event photo identification by non-witnesses.
I see. So Justice Kirby's path was, the evidence was relevant because the police might have had an advantage, but it was opinion evidence, and it was inadmissible opinion evidence because it didn't fit the lay opinion exception in SIS 78 or any other exception.
You've got it. So, two different lines of reasoning converging on the same result. The majority, irrelevant under IS 55, Justice Kirby, relevant but inadmissible opinion under IS 76, not saved by IS 78.
But the bottom line was unanimous.
Unanimous outcome. Whether deemed irrelevant or inadmissible opinion, the High Court concluded that the evidence from Senior Constables Crampton and Peterson identifying Mr. Smith from the bank photos based on their prior dealings should not have been admitted at his trial.
And what was the direct consequence for Mundarra Smith himself? What order did the High Court make?
On June 21, 2001, the High Court made its orders. They allowed the appeals, They set aside the decision of the Court of Criminal Appeal, and most importantly, they ordered that Mr. Smith's conviction and sentence be quashed. And they directed that there should be a new trial.
A new trial. Not an acquittal, but a chance for the prosecution to run the case again, presumably without that key police recognition evidence. Why a new trial?
The court noted that a new trial wasn't inappropriate because the photographs themselves were still properly in evidence. It would be open to a jury, they suggested, to look at the photos, look at Mr. Smith, and potentially reach their own conclusion about identification without the inadmissible police testimony influencing them.
Right. So the core evidence, the pictures remained, but the interpretation offered by the police was out. A huge victory for the defense team led by Patrick Byrne, SC.
Absolutely. And this ruling sent significant ripples, maybe even shockwaves, through the Australian legal system. It fundamentally changed how courts had to approach identification evidence based on recognition from photographs or videos, especially when the identifying witness is someone like a police officer who knows the accused from prior contact, but wasn't actually an eyewitness to the crime itself.
It really clarified, with the highest authority, how those key sections of the Uniform Evidence Act, Section 55 on relevance, and Section 76 and 78 on opinion evidence apply in this very specific, but increasingly common context of photo identification.
It served as a clear signal to police and prosecutors. You can't just automatically rely on an officer who knows someone saying, that's him in the picture. That statement has to pass the relevance test. Does it rationally assess the jury beyond what they can do themselves? And if it's opinion, it has to fit an exception. The Smith decision set a much higher bar.
And as your sources touch on, this legal ruling didn't happen in a vacuum, did it? It landed amidst, well, quite tense public debates about race, policing, and justice, particularly concerning Indigenous communities in areas like Redfern. There were existing concerns about things like photographic profiling.
That's right. The social context is important. The media attention, dubbing it the hooded bandit case, definitely highlighted how a seemingly technical legal point about the admissibility of photographic evidence could intersect with and amplify these broader societal issues and concerns about the justice system.
So a case born from a suburban bank robbery and those crucial yet apparently very blurry security photos didn't just impact one man's trial. It forced a fundamental reevaluation across Australia of how we prove identity from images in court. It really set a precedent.
Yeah, if we sort of zoom out and think about the bigger picture here, the Smith case is just such a powerful illustration that courtroom evidence, even something that seems as straightforward as a photograph, has to pass these really strict legal tests. It's not just about gut feelings or initial impressions.
Right. It underscores that just because someone, even a police officer, says confidently that's him, doesn't automatically make it reliable or admissible proof, especially if the jury is actually in just as good a position, maybe even better by the end of a trial, to make that judgment call themselves.
Absolutely. It reinforces the jury's role as the ultimate decider of fact. They aren't meant to just, defer to someone else's conclusion no matter who that person is. Their job is to make their own determination based on the properly admitted, relevant evidence presented to them.
And this case became really a cornerstone reference point for how identification evidence is handled legally, didn't it? Especially as we've moved even further into this age where surveillance cameras, CCTV, phone footage, it's just everywhere.
Definitely. Its principles are constantly being applied and debated in new contexts.
So what does all this mean for you, listening to this deep dive? I think it means that the legal system, even when faced with what looks like simple visual evidence, a picture, a video, has to constantly scrutinize it. Is this truly helpful? Is it fair? Is it potentially misleading?
Yeah. That blurry image in a security photo wasn't just a challenge for the police trying to solve a crime or the jury trying to reach a verdict. It actually captured a flaw, or at least a point of confusion, in how identification evidence was being used in practice. And it took a major high court ruling to clarify the principles and correct the course.
It leaves us with a really important question to consider, doesn't it?
It really does. In our increasingly visual world, with cameras seemingly on every corner, recording so much, how do courts continue to ensure that the identification evidence drawn from all these images truly assists the search for truth and justice, rather than potentially hindering it or leading to wrongful convictions?
It's a complex question, one that Smith v. the Queen forced onto the main stage, and certainly one worth pondering long after this deep dive concludes.